Welcome to Gavels Down, Voices Up with me, Rachel King. This is where we leave convention at the courtroom door and dive into your real stories, bold and unpopular opinions, and change-making ideas that really shake the legal world up and change where change is desperately needed. I'm here to shake it up, talk about unfiltered insights, and amplify voices that need to be heard. So are you ready? Let's get it. Put the gavels down and the voices up. Welcome back to Gavels Down, Voices Up. My name's Rachel King, and have you noticed that I really love this sweatshirt? I got it off of Amazon. If I was one of those cool people, I would have the link somewhere in my bio, but I'm not an affiliate. I just really love this sweatshirt. It's tunic length, and I wear it a lot. Now that we're here and we're back together again, we're going to talk, as promised, about conservatorships and guardianships. In some states, they call guardianships adult guardianships as opposed to children's guardianships or minor guardianships. In California, we call them conservatorships if it is for somebody that's over 18, and guardianships if it's under 18. But it is kind of the same idea that in both cases, you are trying to take decision-making power, authority to be able to make decisions on behalf of another human being. For minors, it's presumed that parents get to do this, right? You have a child, you don't have to go to court and be like, can I consent to medical treatment? It just happens. You get to enroll your kid in school and put them to church or whatever you're going to do. That's not the case if it's not your child. So if mom or dad both die, then we have to have somebody else that can come in and can make those decisions. And so that would be where we go into the courts to get guardianship. In a conservatorship, right now you reach 18 years old, but you have a developmental disability maybe, or you get dementia or have a stroke or have some kind of life-changing condition that makes it so that you can't make your own decisions. Now we're looking at conservatorships in California, or adult guardianships, as I'm told they are called in other states. I'm going to go with the guardianship minor story. It's really sad when both parents die. I think if both of us were to die, my husband and I, my kid's life would be changed dramatically. And I believe that every child that has lost a parent will agree with that. But again, if it's your child and you are alive, you get to make your decisions. Typically, when you die, when both parents die, the family member has to go in and get guardianship. And we all understand that. There's a legal process to it. It's a pain in the butt, but we get that concept. So now, mom and dad are divorced. This is a real life story. Actually, it's a real life story that has happened multiple times since I've been practicing. The facts have been changed a little bit in every different scenario, but the general gist is this. Mom and dad are divorced or they were never married. They co-parent a child, but they don't co-parent as well as maybe we would hope. They don't get along. Okay? Maybe that matters, maybe it doesn't. But mom has a life insurance policy at work, and it's not huge. It's like $25,000. She doesn't really have anybody she wants to leave it to. She doesn't want to leave it to her parents. She definitely doesn't want to leave it to baby daddy, because who knows what he'll do with that. So no surprise, she adds her daughter to the beneficiary designation form, 100%. So daughter gets 100% if something happens to mom. At the time mom does this, daughter is 8 years old. So if something were to happen to mom while daughter was a minor, that would be an issue. If mom lives for a very long life, then it doesn't matter. Daughter would inherit automatically at 18 or after she was 18. So this is what happens. Mom dies in a motorcycle accident when the daughter is 18 years old, but still has that same life insurance policy. Daughter cannot inherit at 14 years old. She's not allowed to. She's not 18. She can't collect on it. Life insurance wants to pay out these proceeds. Dad, can he just go collect it? I mean, he is the parent, and parents are presumed to make all of the decisions. They can go open bank accounts for their kids. They can authorize blood transfusions. They can authorize so many things without anybody thinking twice. So dad goes and he's like, hey, this is my daughter's the beneficiary of this life insurance policy. Here's the death certificate. I'd like to collect it. The life insurance company laughs at him and is like, yeah, right. We're not giving it to you. You're not the beneficiary. So dad It's like, oh my gosh, I don't get it. What the hell? And then dad calls me or calls an attorney and says, why can't I collect my daughter's life insurance policy? I'm dad. Because you can't, because nobody trusts you, quite frankly. You could be a real stand-up dad and really want to do all of the right things and know in your heart that you're never going to spend the money and you're going to invest in all of the things. Guess what? Nobody trusts you. The law doesn't trust you. So in those circumstances, dad or the parent has to go into court and get a guardianship or permission to capture that inheritance and hold on to it. And then the court will oversee dad with that money all the way until the child is 18 to make sure dad doesn't spend it or do something he's not supposed to without court permission. And in California, probably in other states too, I can't speak to other states, but in California, there's really strict rules on what that can be used for. You can't just use it for like your kid's food. No, the court's like, that's your kid. You get to support it. The inheritance they received is for when they're an adult. It's not yours to spend. So that's one situation where a guardianship that I see happen all the time. It happens all the time. Now, what can I do to make sure that doesn't happen? Because guardianships are expensive. It was in that situation only a $25,000 life insurance, which 25 grand, nobody's going to sneeze at that. But really, once we start getting lawyers involved and courts involved, it can evaporate. There's not a whole lot that can be done. There's some trusts that can be set up. So definitely you want to talk to an attorney to see if that is how it can be done to protect it so you don't end up in a huge, expensive court overseen situation. I've asked the court to allow the money to be released and put in a blocked account. That's basically where we don't have the court continue to oversee it, but it's an account that's locked that nobody can withdraw money from until they have a court order. That can save a lot of legal fees and legal time. The downside of a blocked account, though, is that they don't typically earn very much interest. They earn something. It's like the worst interest the bank offers. Also, it can be a bit of a challenge to get a bank that's willing to do it, but hopefully you'll have an attorney that will help you through it. So that's a lot about guardianships. The most common reason that people get guardianship, and that is when both parents pass away and we need somebody else to step in. But we also have guardianships in situations where the parents are unfit under the Health and Welfare Institution Code in California, and there's some other laws, family law codes, and every state has something along those lines. What does it take for a parent to lose their ability to parent? I like to say that we have a fundamental right to screw up our own children. Okay, so this means that if you decide that you want to put your kids in front of gaming systems 24 hours a day, not monitor their sleep, let them eat Cheetos and Starbursts all the time and drink Monster energy drinks. What's another one that's really bad? Like Mountain Dew, and that's the entirety of their diet. Arguably, you're allowed to do that, right? Like you get to screw them up if you want. Maybe some people are thinking, it's not a screw up. That sounds delightful. Okay, so again, to each his own as far as raising kids. So when we're talking about unfit parents, we're really looking at things like abuse. We're looking at things like physical abuse, neglect, mental abuse, substance abuse of the parent, something that's very serious. And you can get a guardianship. You can go in and say, hey, these parents can't participate or are unsafe, and so I should be the guardian. Independency proceedings, that's like when Child Protective Service is involved and remove a child. Sometimes they'll look to family members and say, hey, can we make you the guardian of this child because the parents are not okay. Less common, but still around, are times where the parents kind of voluntarily relinquish control. Maybe they were very young teen parents, or they have a life that they want to live, or whatever the personal situation is. And they say, hey, mom, dad, can you take care of my kids? Like grandma, grandpa, or an aunt, or it's typically a family member. I don't want to parent, so I'm giving you the ability to do so. That also can require a guardianship. So that's kind of the overview of when a guardianship comes into play. You do have to go to court. You do have to be in front of a judge. You do have to show the judge why the guardianship is necessary. And then the court's probably going to have some questions for you, like, are you a criminal? Have you committed fraud? Do you have a registered sex offender living in your house with you? Why do I say all of this? Because it's come up in all of my cases. Not all of them, but I've had all of them come up in different cases in different situations. The court cares about that. If they're going to be trusting you voluntarily to take care of a child, they want to make sure that they're putting this child in a safe place, not putting them in with a serial killer or a really bad person. I don't know, Ted Bundy. Like, they don't want Ted Bundy to be your side piece, right? They want to make sure everything is on the up and up. If you do need to get a guardianship, I definitely recommend reaching out to your local courts. Oftentimes the courts and the clerks are very helpful with not necessarily giving you legal advice, but with giving you resources. I know in Riverside County, California, the courts even have classes that can help you get through this for guardianships and for conservatorships. Don't worry, I'm going to get to conservatorships. And so that's something to look into. Of course, you can talk to an attorney. I love doing guardianships and helping people out through this process because it can be really stressful. Not quite as stressful as a contested probate because you're not always dealing with grief, though sometimes you are, but it's trying. It's hard to figure out how to take over raising a child that's not yours. It is usually the result of some kind of loss or something bad that's happened. And many times, though it's so amazing that we have family members and friends that step up to be guardians, they're kind of getting used to this idea too. I've had multiple grandparents who have told me, though they love their grandchildren and they would raise them again in a heartbeat, man, I already raised my kids and I thought I was done. So it's a lot. It's a lot. It's heavy. It's amazing. But having the legal support, emotional support to get through a guardianship, make sure that you're doing everything that you need to, but not more than you need to, could be really helpful.
And now for a quick break. This episode of Gavels Down, Voices Up is proudly brought to you by King Law Firm Attorneys at Law Incorporated. We're not just about winning cases, we're about making a difference. Whether it's family law, probate litigation, or standing up against elder abuse, we bring experience, empathy, and excellence to the courtroom. At King Law Firm, we're more than lawyers. We're your team, in your corner, advocating for your rights and making your voice heard. Visit us at thelawyerking.com and on the socials at The Lawyer King to see how we fight with you and for you. King Law Firm Attorneys at Law Incorporated, where your fight becomes our fight. Now, let's get back to today's episode.
So now that child is 18 years old, right? Mom and dad didn't die. Everything is swimmingly. And that child, we do conservatorships for, of course, developmental disabilities, a child that had some kind of developmental disability all through their minor years. Parents could make decisions and then they become 18 and we need to get a conservatorship. That does happen. We do have conservatorships for people that are older, have dementia, early onset dementia, a cognitive impairment, a stroke, some kind of health condition that requires them to have somebody step in to make decisions for them. We do that too. One of the things that I actually have seen a few times, which, gosh, maybe it's like every parent's worst nightmare. It would be my worst nightmare, is that your children are beautiful. They've become more than you could ever imagine. And they turn 18 and they go to college. They do all of the things that you wanted them to do. You're so proud. You love talking about them, probably more than anybody wants to hear. And then they get into some horrific accident. Motorcycles come up a lot, so I'm going to use motorcycles again. They don't pass away, so that's a blessing. But they can't care for themselves anymore. They have some kind of brain damage, a traumatic brain injury. Maybe they have some kind of mental health condition that is a result of that brain injury, and they simply cannot take care of themselves. So we have to go in and we have to get a conservatorship. In all of those cases, we have somebody who's 18 years old who cannot take care of themselves. And under the law, again, we presume that you as a human over 18 years old get to make all of your own decisions. You have a fundamental right to be you and to make decisions on your behalf. And so taking away that power is hard. We don't want people to just be able to do it willy-nilly, right? So we go into court under a conservatorship. We tell the court why we think a conservatorship is necessary. We make all of the arguments under the law. We provide all of the proof, and then the judge makes the decision. Yes, a conservatorship is necessary, or no, a conservatorship is not necessary. Sometimes, as we saw in Britney Spears, the conservatorship may be necessary in, 2013. I can't remember if I have that date right. But then when we get to 2023, it's like, that's not quite necessary. Sometimes a conservatorship is necessary only for a couple of years while that traumatic brain injury gets better. In that case, we were able to go in. We got a temporary conservatorship. Parents were able to make the immediate decisions regarding surgery, rehabilitation, stepping in to make sure that all of the bills got paid, handled that child's life. So excited to say that 3 or 4 years later, that child was able to, it wasn't completely back to normal or back to pre-accident, but they were able to be self-supporting. They were able to hold a job that provided them enough income to take care of themselves. They were able to really live an independent life, and they were expected to be able to live independently for the rest of their life. So at that point, the conservatorship was no longer necessary. We went into court and told them that. So this is a very roundabout way to say that conservatorship are the ability to go into court, ask the court permission to make decisions, everyday decisions, life decisions, financial decisions, even reproductive and voting decisions if necessary, marital decisions, medication decisions, doctor decisions, all of it. You can get all of those powers by going in and getting conservatorship in California. Now, post Brittany, we've had a lot of change in legislation. I think there was actually supposed to be a change of legislation back in 2005, but government operates very slow, so that didn't happen. But then we have this big Brittany issue. And so there has been a lot of legislation and a huge push, not only in California, but I've seen it really around the country to have least restrictive means. So yes, what does that mean? That means maybe this person needs help, but do we really need to take over all of their life and every decision-making power? Maybe not. Maybe we can go in and help by having the court authorize the least restrictive means to get them where they need to go. Things like supported decision-making, limited conservatorships. Of course, we want to make sure that these individuals, these adults, get the help they need, but we don't want to take away their independence. We don't want to take away their identity. We want them to be the best version of themselves. So that's really the direction that I think conservatorships are headed, and I really think that's better for everybody involved. In any event, if you have a child that is under 18 that has a developmental disability and you believe that they're going to need a conservatorship, starting sooner rather than later is better. I often start talking to parents around 16, 17 years old, so it can be in place at 18. If you have a friend, a loved one, a spouse, a boyfriend, a girlfriend, a child, any of the things that's over 18, and something happens, we can go in on an emergency basis to get that emergency conservatorship, those emergency powers, so that we can take care of that person while they need it, especially in an unexpected situation. If your parent, your loved one is aging and has some of the natural breakdown of the body, it's sad, I'm starting to feel it now. My eyesight is just not what it used to be. We can go in and we can start looking at ways through least restrictive means or conservatorships to get them the care that they need. Do we need to put in protections to make sure that the money is not misappropriated and that their bills are still getting paid and that they're getting the doctor's appointments and medication they need? We can look at all of that. So no matter where it is, whether it's 18 or whether it's, oh my gosh, days before the end of life, we can come in and make sure through the legal process of conservatorship that that individual has what they need. If you have any questions on conservatorship, definitely reach out to, again, your local courts, your clerks, attorneys, of course. That's what I'm here for. And really talk to people that you don't want to be the person that relies on Facebook, I always say, for your legal advice, but getting information and getting people's stories can be really helpful, even if it just makes you feel like you're not alone. So now, after we've talked about conservatorships, we've been all over that entire area of law in, just minutes. I hope that you are armed with knowledge that will help you navigate these pretty stressful and unexpected situations a little bit more confidently, and that you know what you can do and you have some information in the event that you are ever faced with having to get guardianship or having to look into conservatorship options. Certainly, if you're looking at ways to prevent or make them easier in a guardianship situation or a conservatorship situation for your family, talk to an attorney. There are tons of things and options available. Have you experienced a guardianship or conservatorship that you learned something new, or you thought, oh my gosh, I can't believe this just happened? Let's share it. Let's come together. Let's be a community. And knowledge is power, right? So the more we all know, the better we can move through. My name's Rachel King, and until next time, this is Gavels Down and Voices Up. Thanks for tuning in to Gavels Down, Voices Up. Like what you heard? Then don't just sit there. Subscribe, share, and tell me your thoughts. I'm Rachel King, bringing not just my opinions to the mic, but about the courtroom too. Your part, keep listening, keep engaging, and until next time, let's keep those gavels down and our voices up. Unmistakably up.